Good evening and good to have you with us in the 9 p.m. edition of the Urban Debate. We put the spotlight on yet another interesting part of the way our investigations and our judiciary functions. Now, let me first tell you what has happened that led us to deciding we should have this conversation today. Yesterday, the Supreme Court, while hearing a plea, said that it was shocked to learn that a bail plea was not even listed for a hearing for over a year. To put things in perspective, let me give you a background of this case and how it landed up in the Supreme Court. Now, this is a case which is known as the infamous Bhola drug case, which was cracked down on about a year and a half ago. Now, in this case, the ex-president of Municipal Council, Chunni Lal Gaba, was made an accused. It's a multi-crore drug racket case. And this man, who is also a businessman and a millionaire at that, was made an accused in this case. There were multiple charge sheets and investigations. ED filed a charge sheet under PMLA. There were also several other acts, NDPS Act, that was used against Gaba and even his family members. Now, he was granted bail on March 28th, which was then extended to July. The ED moved High Court opposing this extension of the interim bail, and hence his interim bail was cancelled on July 4th, 2020. That's almost a year ago. Gaba has been in judicial custody since then, with his bail plea pending before the Punjab and Haryana High Court since February 2020. Because it went on for so long, there were roughly about 20 odd adjournments and extensions on these dates, a classic tariq pe tariq kind of a scenario. At this point, this accused moved the Supreme Court for some relief. This accused is 73 years old, suffering from various kinds of ailment. This accused plea in High Court was for bail. They went to the Supreme Court and said, despite these conditions, age and health conditions, High Court has shown no urgency to hear our bail plea. There have been over 20 adjournments. And so the Supreme Court said that we are shocked to see that the bail application wasn't even listed for over a year. Now, here is the operative part. Often we hear it from our top court, but not very often does it get applied on paper. So every time we do see the top court or any other court highlight these aspects, we feel it is important to highlight it as well. The Supreme Court said that the accused has a right to hearing of his application for bail. Denial of hearing is an infringement of right and liberty. That non-listing of such an application defeats the entire process of justice, defeats administration of justice. Detention of an individual infringes his right to life and liberty as guaranteed under Article 21. Repeatedly, we are told, bail is the norm, bail is the rule, not jail. But repeatedly, we find more and more instances that on ground, in reality, it is jail which is becoming the norm in many cases. Usually, it's judicial backlog, it's delay in paperwork. Often, it is the investigative agencies who find ways of delaying the whole thing. They come up with one after the another delaying tactic where the courts then can't do much. For example, let's take the case that we've been talking about here on Mirror Now the last couple of days. The case of release of Natasha Narwal and Devangana Kalita and Asif Tanha. Now, the High Court ordered bail in this case 2 days ago. It took 2 days because they had to go back to the lower court, file an application for the release after the High Court bail order. And then the Delhi police found reasons. They said, we will take time to verify the addresses, to verify the sureties, to go into the details, do all of our paperwork. We have to travel to this place and that place to verify the permanent addresses. And so they ensured that these activists, student activists, spent 2 more nights in jail. Delhi police was perhaps hoping they can delay it as much as they can while their plea challenging the High Court bail order gets heard in Supreme Court, which is happening tomorrow. But tonight, these youngsters have been released from jail. So they at least have tonight until the Supreme Court decides tomorrow. That being said, let's debate the larger conversation here of how even bail hearings in our country can get delayed for over a year and what needs to be done to fix this. I say good evening to Sanjay Hegde, Senior Advocate with the Supreme Court, Gunjan Singh, Advocate with the Supreme Court as well, Vikram Chaudhary, Senior Advocate with the Supreme Court as well, A.S. Ponnanna, Senior Advocate with the High Court of Karnataka, former Additional Advocate General for the Government of Karnataka, joining us this evening. Let me start with Sanjay Hegde. Mr. Hegde, it was very interesting to see the Supreme Court say we are shocked at the way for over a year a High Court hasn't found time to hear this bail plea.
Well, it's a rare matter that can, or a rare man who can come to the Supreme Court. These kind of delays are endemic in a lot of courts, the High Court and even the trial courts. And quite frankly, I do think that human liberty is not very valued in this country. There seems to be some kind of implicit acceptance in the system that, you know, if the police have charged you, then you must have been guilty, you must have done something wrong. And that pending the trial, because we know that the trial will take a long time, let's see, you stay in custody for some more time. When you finish near half the maximum sentence, that's the time that we have to seriously think of releasing you on bail. The very concept of a presumption of innocence does not seem to weigh in at the stage of the bail application. And the pandemic has been an additional factor. Previously, there used to be 2 or 3 benches in the High Court dedicated to bail petitions. Benches have not had the ability to sit continuously, nor have matters been continually listed. So it's very easy for matters to slip down the cracks. Now, this was a big man. He managed to come to the Supreme Court. A lot of people just rot within the system. And I do wish the Supreme Court's voice is heard fervently, that hearings, especially in bail petitions, are expedited, and there must be some prisoner tracking and processing system which essentially works on the basis of how many days has the man already been inside and what is the maximum that he can possibly be required to serve, and why should that period not be shortened. The state sometimes seems to think in almost every matter that you know, it is better that the person remain in jail. You forget that often that may be the only allegation against the man, or only one case. You turn possible infractors of the law into hardened criminals by the time the process is over. Jail in itself is an education.
Yes, you're right there, but maybe not an education that everybody wants to go through. But let's talk about what you said as one of the reasons which has just made the matters worse. And I want to take that point across to Gunjan. Gunjan, because of the pandemic, has it just made the matters and the backlog even bigger?
See, definitely. I mean, considering the ongoing crisis, where even today, the present case which you are discussing, as Supreme Court observed, that we would request half of the judges to sit on alternate days and decide the matters. That speaks volume about the, seriousness of the event, that how in many cases, many high courts, a simple bail application takes months to get listed. I mean, this was as rightly pointed out by senior advocate, that he was a person who had resources. He came all the way to the Supreme Court. But think about all those people whose bail applications are pending for months. They are not being listed. They're not being heard. And even second aspect I would like to highlight, that in most of the cases where people are even getting bail, even to file a surety and to fill the bail bond, that is a task in itself. Many people in this country are languishing in jail because they don't have surety. Often weird conditions are imposed by courts, that local sureties, people are arrested in different states, and that is how many people are languishing in jail. So considering the ongoing pandemic, this situation is accentuated, this crisis is accentuated, and many people are languishing because of this.
Can you give an example, Gunjan? Can you just elaborate this part about, say, you're not from that place, you're from another state, and you're asked to give a local surety?
I'll just give an example which I happened to do a case way back in 2017. There's a very famous posh society called Mahagun Society in Noida, where few a domestic worker was being beaten up and ultimately killed. And the allegation was against some owner. And then domestic workers went to the Mahagun Society, they protested against that. And many people were charged, domestic workers, and they were put in jail. Mostly they were charged that there's a people from Bangladesh, and that is how that whole episode also got a communal color.
Right.
And in that case, when people got bail eventually, they didn't have anyone in Delhi who would give them surety. So they all had people from West Bengal. And then the police took some time, as you see today in Natasha's case and all these three cases, where Delhi police was trying to buy time. I mean, everybody knew why they were buying time, because they had to go to the Supreme Court and they never wanted them to come out of jail. In that case, they sought time that police will go and verify addresses of the sureties from West Bengal, and then they came. It took almost a month for them to come out of the jail, despite having a bail order in their favor. So that is the reality, that even poor people, they don't have social capital. They don't know people in different places, like a migrant worker. Suppose a migrant worker from Bihar is going to Chennai and he happens to be in jail for some sort of a petty crime. And if a court imposes a condition that you'll have a 2 local surety, how will that person get a surety who will have a 50,000, some sort of a, challan or a vehicle card or a fixed deposit, which you have to produce as a surety? That would not be possible. So these are bail conditions which often makes conditions more difficult for poor people.
Okay. No, you're absolutely right. So on one hand, Mr. Ponnanna, you have the most powerful, visible, influential people who would also have the money and the reach to get to the Supreme Court and get an immediate bail, even before the police can get around to doing their basic work. Then there are those like Mr. Gaba who waited for a year but still managed to at least have the wherewithal to reach Supreme Court and get this relief. And then there are those like Gunjan was given example of, who don't have any help and so continue to languish in jails. Now, how do we fix that part? Mr. Ponnanna, the question to you. I'm not too sure if he is able to hear us. Mr. Ponnanna, can you hear me? Okay, we're going to fix that line with him in just a bit. Let me take that question to Vikram Chaudhary then. Mr. Chaudhary.
See, Tanvi, there are 2-3 facets to all this. I must first start with saying that what the government had given a data in the parliament in 2019, that there are about less than 20 judges to a million population in this country. So the judiciary that we have is one of the most efficient and sensitive ones. They are clogged with work, but even during this pandemic situation, the response was tremendous. All the honorable judges in all across the country have come prepared with their files. They have been reading them. They've been trying to dispense justice at every threshold and in every possible way. Having said that, the malaise that we are addressing today is actually related to large-scale bail reforms that are, I would say, long impending in this country. Those reforms have been addressed by the Law Commission of India in its 268th report, in which they used the words that the bail system in this country is inefficient and inadequate. They also said that drastic measures have to be taken to improve the system. Identifying these drastic measures, I would first go on to three facets which are actually affecting the entire system. Those three facets would be, first is indiscriminate arrests. The power of arrest, the Supreme Court has said in a celebrated judgment, power of arrest is one thing, existence of power of arrest is one thing, but exercise of that is quite another. Unfortunately, the arrests have been made indiscriminately in this country. They are made sometimes when even the incriminating evidence justifying such arrest is not enough. The Parliament made an amendment and brought in Section 41 in CRPC, which is the power to arrest. They brought in a provision that where the offence is punishable up to 7 years, a few yardsticks were prescribed, and unless those were fulfilled, arrest should not be made. Still, the provision was being flouted. The Supreme Court in Arnesh Kumar, again a celebrated case, laid down those guidelines and said that if the police officer doesn't do it, or even if the learned magistrate at the time of remand does not consider this provision or apply this in letter and spirit, there would be some action taken. But unfortunately, those have not been adhered to. In the recent case of that comedian Munawar, the Supreme Court had to come down, and I happened to represent that as well. And it granted bail merely on this ground that the principles laid down in Arnesh Kumar or in Section 41 were not adhered to. The second aspect, indiscriminate arrests, which leads to the bail process being initiated, the courts being called upon to grant bail. The second aspect would be the unjustified opposition to the bail.
Yes.
So, assuming that arrest was necessary in a given case, it may be necessary to unearth some modus operandi, interrogation may be necessary. But then after some time, when a person has gone into a judicial custody, a lockup, we have overcrowded prisons. Infrastructure is crumbling down. This is in the Law Commission report. There is huge sanitation, health issues there. So why there is an unjustified opposition? And probably the unjustified opposition stems from 2 or 3 fears. A person may be a flight risk. He may tamper with the evidence. He may otherwise misuse the liberty. Now, all these 3 concerns could be addressed if in the Law Commission report, a very serious recommendation, and I feel that this is the right time for this country to adopt, which is electronic tagging. All developed nations of the world have electronic tagging system, where a person is electronically tagged. It's kind of a Bluetooth GPS device. So wherever he goes, the tracking is monitored in a centralized system. So a person cannot escape. He remains in the confines of a particular jurisdiction. So these kind of measures would have to be adopted to stifle this unjustified opposition. And sometimes it is actually just for the heck of it or just for opposing it formally. So this also clogs the system. The third aspect is, of course, the delay in disposal of bail. And that delay is attributable not to the courts alone. It is attributable even to the counsel for the accused, like us, or the state councils, the lack of records, the lack of assistance by the investigating agencies at the appropriate time, and of course, the courts being overworked. Too much of work before the courts. They are all sensitive issues to be addressed. So in order to, this is a heady combination of all these factors, and the state, I believe, has to be a virtuous litigant. A model litigation policy is necessary. Unless they stop either on indiscriminate arrests, or they stop in unjustified oppositions, or just stifling the proceedings in a given case, the delay would be immensely curbed because state is the majority litigant in this country.
Absolutely. Absolutely. And sometimes the state gets so blatant. I mean, there is no subtlety left at all in the way they come up with reasons and excuses to oppose to delay just to whatever point it is that they want to drive at, depends on the case. Let me take that point across to Mr. Ponnanna. Mr. Ponnanna, good evening to you. According to you, what is one of the biggest reasons that we still see such large pendency of bail applications and people languishing in jail for years together? Is it the apprehension of certain courts or judges to give bail while knowing bail should be the norm? They don't want to take that option. Is it indiscriminate arrest or simply pendency of cases in courts?
No, you see, the criminal justice dispensation system is totally overwhelmed. It is a combination of all these aspects that you just pointed out. Arrests being indiscriminate. Magistrate, for example, in Karnataka, you can pass out from law school or law college and become a magistrate. So what are you facing when you go before a magistrate with simple offences? He is unable to straight away decide the matter. He has to give time to the prosecution. Prosecution takes its own time. See, these are all factors one after the other. So by the time you reach the higher courts, it is believed, it used to be the system, that cases which are very heinous in nature, where the sessions court or the magistrate was unable to grant bail because of the nature of the offence, only those kind of cases come to the high court. At least that is how it was when I started my practice. But now every second case is before high court because these lower court judges are afraid to give bail. In every case which is of some, gets some publicity. And the media, you know how the media is overhyping this to feed the viewers. Judges are today afraid to dispense with justice in the real sense. So all this combination of how the system is virtually breaking up, if you ask me. And the fact that bail should be a norm, jail is an exception, these are all just mere words. So in reality, it does not happen. In every economic offense, they bring in cheating without even understanding what the concept of cheating is. Judges, 7 years imprisonment, magistrates don't want to give bail. So in a matter which should be done with on the same day that you are produced for court, you come up to the sessions court, which takes a couple of weeks to be decided. Then anticipatory bails, it takes, I can't even tell you how much time these cases take up. But then when you come to the high court, I mean, from notice to the prosecution, and by the time he's ready with it is 2 weeks. So a person who's perhaps not, couldn't even be alleged of having done any serious offense is languishing in jail.
So one obviously is a larger aspect which about pendency of cases, which we hope at some point we get around to. But I want to focus on things that can otherwise, Mr. Sanjay Hegde, be looked into. Repeatedly, Supreme Court or even some of the high courts will say bail is the norm, not jail. But on paper, it doesn't take place. Now, like you said, it could also be apprehension of the sitting judge. To say, let him be in jail. Why, look into it right now? Can that be addressed in any manner? Is there a solution there?
I actually think that, as Ponnanna said, sometimes at the lower, things which could properly be addressed at the trial court level unnecessarily get dragged to higher levels simply because judges there feel inhibited. There is a certain sense where the appellate judge tends to distrust the judge of first instance. And then the high courts tend to distrust what the district judges do, and so on and so forth, up the ladder. If somebody is granted bail, if the conditions of bail are adhered to, and the conditions appear to be reasonable, there should be no reason why judges at the trial courts should be asked to explain why bails were granted in certain cases. Often it so happens that the judges of first instance do not have constitutional protection. They can be hauled up for disciplinary proceedings before the high courts, and sometimes some unwarranted talk also travels up the system. Therefore, if there is any matter which draws media attention, the invariable response in a court of first instance is Okay, let's send it up the system. Let's deny it at the first instance. Let somebody who has constitutional protection, who doesn't have to worry about his job, let him or her handle it. I think this, if there is a concentrated attempt on the part of the higher judiciary saying that we will not normally call these decisions to question, at best we will speed up trials, then I think we won't have so many bail applications clogging the system. But this is just my personal opinion.
What about cases, and I take this to Gunjan and then to Mr. Chaudhary, what about cases where it's so clear that it's an attempt by the state to delay? What about, for example, the case of Natasha Narwal and others, where the police said they will take 3 days to verify an address? I mean, these are, at the end of the day, as per police's own claims, the most serious accused under the UAPA Act for indulging into terrorist activities, Gunjan. And then the Delhi police turned around and said, we will take 3 days to verify their address, so you can't release them, obviously because they were going to Supreme Court.
See, as we have repeatedly said, I have said time and again, that state very well knows that process is the punishment. They very well know in most of the cases that this case will go to the High Court, the person will get bail. But that whole process is a punishment. Now you go to the trial court, then you have to go to the High Court, then you have to go to the Supreme Court, and we see how cases are listed, then adjournments, then multiple, even after bail is granted, then you see this verification thing. So police very well knows this aspect. That is how I feel that it is judiciary. I don't have much faith on what state is going to bring law commission recommendations and they're going to change, because it is most of the times we have seen these are political cases where state is very much interested to put these people behind the bar. So it is judiciary which has to step in, and particularly the lower judiciary, which unfortunately in most of the cases when we see that there is a high profile case, when the charges like sedition are attracted, most of the cases we see that trial court judges refrain from passing any order. I mean, we do have exceptions and we do have good orders like we saw in Disha Ravi's case and all that. But in most of the cases, trial court, we don't get at trial court level, and often it goes to the High Court. So in order to avoid that the process is the punishment, our lower judiciary will have to step in. Supreme Court may pass certain guidelines, like in Arnesh Kumar it is there, that application of judicial mind is necessary. Not merely the writings in the FIR. A judge has to apply its mind and see whether there is something necessary to arrest. The phrase used in Arnesh Kumar is whether it is necessary to arrest. Now there is where trial court judges and our judiciary has to apply mind and see that whether this person can be set free or not. Merely commission of a crime can only be established when the trial is over. But at this stage, it is important to see that whether this person will be available for the investigation. That is it. Nothing more, nothing less.
Exactly. Whether this person will be available for investigation, is cooperating, ready to, be there or not. For example, the other example, Mr. Chaudhary, and you referred to it earlier, was even Munawwar's case, where again, various kinds of attempts and claims were early made to just ensure he stays behind bars.
Right. See, there are 2 or 3 aspects which govern the administration of criminal justice system in this country. The most sacred article in the Constitution is Article 21. Article 21 says no person's life or liberty will be jeopardized unless the procedure established by law is followed. Now, Article 21 does not end with the authorities. It doesn't say that it is only the act of, say, police or any authority. Even the act of the court, if a person remains behind the bars or is remanded, say, mechanically, even that is violation of Article 21. Now, presumption of innocence, 2 sacred cardinal criminal jurisprudence principles: presumption of innocence at the stage of trial or a pre-trial, and second is pre-trial bail. These 2 aspects are fundamental concomitants of our jurisprudence. So if there is presumption of innocence vested with a person who may have been arrested or may have been alleged to have committed a crime, and the pre-trial bail is preserved, then we must have some kind of a uniform structure where in most of the cases bail could be granted, like the response to COVID-19 situation. In March 2020, Supreme Court passed a drastic order. The jails were emptied in no time. There was no overcrowding. And that was followed again when the second wave came. If those people could be enlarged on bail or on even the convicts post on parole, etc., then there was the question of putting them behind the bars for such a long time. The 68%, I am told that 68% prisoners in this country are under trials. If that is the position, then pre-trial bail and presumption of innocence, some uniform structure, as I said, if some uniform structure could be followed, then this concept of judicial discretion, which varies from court to court and case to case, may be structured in a manner which is limited to certain category of cases, which may be calling for some kind of a graver menace to the society, where the judicial discretion could be brought in. But if there is a uniform structure, I think everyone in the system would be eased, right from the investigating agency to the jail to the court, the system, there will be a lot of convenience and ease. We need to look at bail reforms in a very holistic and drastic manner, especially in the wake of COVID-19 pandemic, where so many persons, not only in India, UK, USA, developed nations, they release prisoners in a large number. And that is happening even today. So we need to respond to this system in a different manner instead of, say, blaming at a particular, a particular phase at, say, courts or the prosecution or the investigating agency. The accused and the accused counsel are also to take a lot of blame. I know many cases where accused counsel also take a lot of adjournments, unnecessary ones, delay the trials, prolong the system. So we need to look at it in a holistic manner and bring in bail reforms which are necessary and which are, I think, which are crying for justice now.
Oh, you're absolutely right. Of course, the adjournments and demands for adjournments and delays can happen from both ends. But when it is not in the interest of state, Mr. Ponnanna, very quickly to you, this last comment, when it's not really in the interest of state, will they move forward to bring these judicial reforms? There is an entire report by the Law Commission that's just lying there. Nobody's looking at it.
Yeah, of course, the reforms is one way to look at it. But in reality, let us all admit and accept the fact that the system runs on individuals and how they understand the legal setup, right? So you see investigating officers, from the time they join service, they are trained to be these, kind of beasts kind of person. They do have no understanding of what the legal system requires, what is criminal jurisprudence, what is the evidence act, what does the court require, and how do you approach investigation? I have been on the side of the prosecution for 6 years. I work with the prosecution. These guys need to be trained. They need to understand that arrest is not a form of investigation at all. You don't need to arrest people to investigate. You arrest people when they're habitual offenders. You prevent them from restrain their liberty because they may go out and commit crimes. People who are rowdies, people who are into terrorist activities. These are the kind of people you arrest. You don't arrest people in vindictive prosecution cases. And if you take this aspect of the matter into consideration, you will find that 90 out of 100 cases, there is no need for arrest. And this criminal procedure code provides for this, where you can give reasons and record them as to why you are not arresting people. Section 41 deals with this situation. But the policeman has no idea about it. Now you can call a dozen of them on your TV show and ask them if they have ever read the CRPC in their entire lives. Have they really read the Indian Penal Code in this? They have no clue about what the legal system, in the sense what the judiciary needs, what is the nature of investigation that needs to be carried out. There is no correlation between the two agencies, the prosecution and the judiciary. There is no correlation. The prosecution does not understand what the judges want, what the judiciary wants.
Correct.
And what the law wants. So this, you can have thousands of reforms. You can have law commissions. You can have Supreme Court judgment, Arnesh Kumar case. Everything is in place. But you don't have people who are trained to understand these things.
Well, and that's something that we can begin by looking at and bringing on those reforms, training those people, making them aware and making them understand. how these sections need to be used. Completely out of time. It's been a pleasure to have all four of you on this conversation. An extremely concerning problem, not a new one. I mean, we're infamous for the number of under trials who languish in our jails. And thousands of them who are never even spoken about. Nobody even knows. Society, people, everybody simply forgets about them. It's only the few handful cases, high-profile cases, those with some reach, those with some access, privilege, money, power, who are even able to fight and fight for justice at the highest levels and go to the highest levels. Others don't, which is why it's such a big concern. I mean, it's easy to say that, well, there are courts of justice at every level, from trial court to high court to Supreme Court, and you have so many options that you can try. But how many of those in our country can do that, are capable, have the economic and financial backing and legal knowledge to do so? Which is why these changes need to be made. Obviously, the pendency of cases has gone up higher due to the pandemic. The load on the judiciary is way too much. Some of these problems are addressable right away. Depends on who takes the initiative, though. Thank you so much for joining us.